So, welcome everybody to East State Academy. And today we're going to talk about estate law changes that have occurred or are about to occur or may occur in the future. Normally Ian would be here, but he's in the middle of a mediation. So I'm going to try to handle this by myself. Just a few reminders to if you can mute your microphones. Seems like everyone's done that. And hopefully we'll leave time for questions at the end. So welcome aboard, and here we go. So our agenda today is we're going to talk about changes to the preferential share for spouses on an intestacy. Very briefly, we'll handle that quickly. Then we'll talk about the whole idea of small estates and probate for small estates. And then we'll talk about some proposed changes that have been tabled that are not yet law, but are anticipated to become law in the relative near future. So the first thing to get out of the way, here's a change as of March this month. The preferential share for a spouse on an intestacy has been raised from $200,000 to $350,000. So just by way of background, if a person dies with a spouse, and that means a married spouse, the married spouse will receive the first $350,000 of the estate, and then the balance is split depending on who else is around, whether it's just the spouse or their kids. And this is effective as of March the 1st, 2021. So any people who have died prior to March 1st, 2021 are under the old rules. So that's the first thing. That was easy. The next one's is brand new to us. And it's this concept of small estates and probate for small estates. And we're going to talk about, first of all, what qualifies as a small estate. Second, the rules that are applicable to small estates. And lastly, the procedure for applying for probate of a small estate. So the first thing is the term small estate has now been defined to mean an estate of $150,000 or less. So if we're talking about an estate that has that amount or less, then it would qualify as a small estate. You'll see as we get along, you can't sort of fudge it necessarily and start with a small estate and then, well, figure out we only found less than 150 and then we'll proceed throughout, because there are certain rules to catch us on that. So if it's less than $150,000, we got a small estate. So all the regular rules apply for probate of a small estate, except there are changes. So there are new forms and there are fewer forms. An affidavit of service of the forms is not required. And the big change, relatively speaking, is that no bond will be required, even on an intestacy or a foreign estate trustee, unless there's a beneficiary who is either a minor or an incapable person. So while we're used to the idea that you have to bond in every intestacy application, that is not the requirement if the estate is a small estate. So here are the sort of the rules for applying for probate for a small estate. And the fundamental point here is that whereas we're used to a certificate of appointment applying to all assets of an estate, a small estate certificate has the actual assets that it covers in the certificate, so that a third party dealing with them can look at this and say, okay, is this certificate authority to let you deal with this asset or not? So that's the first point. So a couple of things, I'm just going to pull up some of the forms. When we're applying for a certificate, it's called a small estate certificate. It's a new form. Notice I've put the link to the forms are all at the bottom, but I'm going to pull them up in a second. So the first thing that you need to do is prepare an application for small estate certificate, file a request to file an application for that small estate certificate. You need the proof of death, so same as we have now, and you have to provide the court with a draft of the small estate certificate. And I'll get to these forms in a moment. And if it's a will situation, then you have to submit the original will, not surprising, this typical affidavit of execution, and the usual evidence. And that, I mean, if it's a holograph will, then the affidavit about handwriting. If you can't find the witnesses, affidavit, etc. So those kinds of things. If there's a interpolation or there are amendments that have been not subscribed to, then you need the affidavit of condition. So those typical ones that you would always need. So let's stop there for a second. Let me pull up the, first of all, this is the, I'm hoping that you can see this on my screen. Michaela, if you can, just shout out that you can see this.
Yep, you're good.
So this is the form. This is the application. So some of it, of course, is very similar. I'm not going to take you through that stuff. The key here is just some of the questions. They're pretty they're made to be pretty easy. Is there a will? Is there not a will? Is it attached? Those kinds of things. Here's where it gets a little more unusual. And this is where in the application, each asset owned by the deceased has to be listed. So each individual, not this usual, right? We're familiar with the current application for certificate of appointment that just lumps everything, all your real estate together and all your non-real estate together. Well, that doesn't apply anymore for a small estate. If you want this certificate to apply to an asset, then you got to identify that asset and put in the value at the date of death. The typical rules apply for estate administration tax. That is, true joint assets don't have to be included. But any other assets that you would normally include for a certificate of appointment, you have to include. And similarly for the personal property. So you can put in like personal effects. You don't have to itemize each cup and saucer or knife and fork. They can be one general entry. And then you would list every other asset that you have. A bank account, here's the amount. And you would have the bank account number because you want to identify that that's the account that you're allowed to deal with. Again, we don't know exactly how this is going to work, whether we do put in the account number or we don't. We're going to find that out pretty quickly, I would think. But that's sort of different. That's a new concept there. And then you have sort of a bunch of check boxes that are pretty straightforward. I'm the estate trustee. I'm the alternate, but the person has died, whatever it might be, and these kinds of things. So it's pretty standard sort of check marks. And then you have to list all the beneficiaries, both minors and any other adults. And I mean, we'll see if a non-lawyer understands what an unborn or unascertained person might be, but this is not only the people named as beneficiaries, but contingent beneficiaries as well. So just the same rules that you would use in a certificate of appointment in the regular thing. And then you have to declare certain items about the fact of the value and things like that. And those kinds of things. So, and then it gives you some instructions on what to do next, i.e. we'll talk about service in a moment, then file this application, and then, you have to sign off that you're going to administer the estate and keep records and certain things that we don't require currently an estate trustee to or an applicant to check off, but they're doing that in this, which makes sense because the idea is that the likelihood that more people will try to file this on their own without a lawyer and legal advice, they should know sort of what their obligations are. And this one does have to be sworn. So this still needs a commissioner's. This document, along with this notice to beneficiaries, gets given to beneficiaries. And I'll talk about that in a second. So that's the application. I just want to show you now, and I'm just going to move this aside for a moment, that I want to show you the second document. This is the request to file an application. And this goes to the court and just identifies some information about the request for the certificate and what else you might be seeking, dispensing with a bond if that might be necessary, an order that the deposit for estate administration tax be deferred, undertakings, things like that. And these are the, basically a checklist that gets filed with the court to make sure that they have all the information that they need. That's the request to file. And the last document that I'm going to show you, and then I'll get to some questions once I finish this. This is the small estate certificate. So this is what the certificate of appointment would look like for a small estate. And you can see it's pretty straightforward. But what's key here is that here's the property, and you don't include the value or account numbers here. So presumably this would say something like, bank account at Royal Bank. Or something like that, so that it can be identified that that's an asset that's being covered by this small estate certificate. So that's the idea there. And again, you can find these documents at the ontariocourtforms.on.ca website and look them up. So those are the documents that we're looking at to file. Now, what's the procedure? So you fill in all of these documents and you send or give to each person who's a beneficiary, who's entitled to a share of the estate, including contingent beneficiaries. You have to send them the application form and a copy of the will or codicils. If there are minors, that gets given or sent to the parent and the children's lawyer. And how do you send it to them? Well, you can send it now by email, as well as by letter mail or courier. So you fill in the form, the application, you send it with the will to the beneficiaries, and you have to wait 30 days from the date that you've sent it to file the application with the court. Okay, so that is another new twist, right? Currently, for a certificate of appointment, you could do it on this. You have to swear an affidavit that you served them, but you could do that sort of the same day as you file. In this case, there's a waiting period, but there is no requirement that you sign. There's no affidavit of service that you've sent or given these items to, although you do check off a mark, as you saw, that says I've done this. So what happens when it gets filed? Well, the first thing that happens is that the court checks that there's no other notice of objection, there's no other pending application, no notice of objection, and there's no later deposited will in their files, right, in the court's repository. They have to make sure that there's evidence that the estate is a small estate, that they've received the necessary documents, and that the estate administration tax has been paid. And then the registrar will issue the small estate certificate. There's also a provision that a judge could order that a small estate certificate be issued. The registrar could come back and ask for further information. That is a possibility. And if the court rejects the application for a small estate certificate, the applicant or their lawyer will receive notice that it's been rejected. So again, I just continue to make this point that really the small estate certificate only covers assets that are disclosed in the application. So what happens if you think you have a small estate, but then you find additional assets? So there's two cases that could occur. One is that you find other assets, but the total value is still within the small estate threshold. And then what you can do is apply, or what you must do is apply for an amended small estate certificate, because don't forget the list of assets are going to be on the original one, and it's not going to show this additional asset that you found. So you apply for an amended small estate certificate, and there's a form for that, and where it lists what were the current ones and what are the new ones, assets that is. And notice that you can only apply for one amended small estate certificate without leave. Thereafter, you have to require a court order on motion to allow to file an additional or get another amended small estate certificate. I guess they don't want you to just keep doing it as, put in a simple one and just keep adding to it. And then what happens though if you find assets that render this estate no longer a small estate? Well, at that point, you've got to apply for a regular certificate of appointment of estate trustee. And because this won't apply, the certificate won't apply to those new assets. So you need a new certificate. And if it's greater than 150K in total, then you've got, you would no longer qualify as a small estate. So that is an update on this. This is applicable April 1st. And so I'm going to start going through the questions. I hope screen didn't freeze. I think we've dealt with a bunch of these. Good question. So these small estates, they apply whether there's a will or there's no will. The rules apply. So this is not necessarily where there's only a will. This applies in an intestacy situation as well. You would, in that case, you'll see in this small, I'm just going to pull that back up so you can see that the application for the certificate deals with both a situation where you have a will or you don't, because you would just check off deceased died with a will. No. Well, there we go. Now we just do it. So the bonding requirement, you do not need a bond if it's a small estate, even in an intestacy. That's the point there. We will make the slides available. And do you only need to provide a copy of the small estate application, the original, to the beneficiaries? That's right. So the rule for what you have to serve them is the application and the copy of the will and codicils. In this sense, then they're going to have, they're going to know what the value of the estate is, et cetera, right? By virtue of the application. So there's no separate notice that we have under a regular certificate of appointment. There's this new, they just get served with the application itself and a copy of the will. So that's the idea. So that's the idea on small estates. Are there any questions? I think there might be a couple more questions here. What is the benefit of filing a small estate application? Well, the benefit, what's the benefit? There's not much. I mean, probate tax is still applicable. It's I believe, really conceived for non-lawyers, because the idea is that you could file it without getting a lawyer involved. It's a simpler form. You don't need to commission necessarily the notice, the affidavit of service of notice, simpler sort of procedure. Maybe it'll be faster. Maybe if you see these small estate certificates, they'll be faster. I don't know. But you're not saving any probate tax. You still have to pay probate tax in exactly the same fashion. Good question is, what is what's the benefit of that? What do people charge for a regular certificate? I'm not sure it's going to be that much, less work really for us, but and typically people, I don't want to speak for other people, but I charge typically about $4K for a probate application. So. All of the same issues about probate tax apply to small estates. You gotta, it's true, you may have problems getting that information from banks, the same problems we have now. That's true, but you're not in a worse position, I guess. That's the idea. So Does no bonding requirement of estates under 100 apply to the usual? No, it only applies, well, no, it only applies under a small estate. That's a good question. If you need a bond, if the estate is less than 150,000, but you're not proceeding in this way, I will look into that question, and I'll update the slide one way or the other. And that's a good question about whether I have to look at the act and see if what the Estates Act says. Okay. Any other questions? I'll get back to you on the question of whether bonding is waived for a regular application, which has an estate value of less than $150,000 or not. And that's the answer I got to get back to you on. So that's the changes that are coming into place, beginning of next month. So that's to be on our radar. I wanted to talk just briefly in the last few minutes about these proposed changes that were tabled this past month or last month by the government, Bill 245. And the proposed changes, again, this is just first reading, then it'll have to go through the normal course, but we do expect that most of these will pass, and we'll see. So I just wanted to run through you so everybody's up to speed on sort of what's coming down the pike in the next little bit. So the first thing is this move towards virtual presence signing to be extended permanently rather than just in the order. And I'll get back to there are a few more questions, which I'll get back to in a moment. So that's the idea, is that the way we're doing it now during COVID is going to be made permanent. Same kind of rules. You can either do it, in counterpart using an identical copy, or currying it back and forth and getting back on video and having them watch you as you watch them, et cetera. And for powers of attorney as well, the same kinds of rules. Still having a lawyer or a member of the Law Society having to be one of the witnesses if that's the way we're dealing with things. Second change is right now there's a limit. If a minor gets more than $10,000, you can't pay it to a parent. You have to have a guardianship order and a guardian of that property. So the idea is that amount is going to increase likely, something in the range of $25,000. A couple of bigger ones. So removing revocation of wills by marriage. Right now, as you know, marriage is the only change in circumstance that revokes a will. And that has been heavily criticized over the years. And the proposal is that wills will no longer be revoked by marriage. So your contemplation of marriage clause will not be necessary if this is passed. And I just want to reiterate, in case you're just joining us, these are not passed laws yet. This is what we expect. This has been tabled, and we expect them to come through, but they're not in effect, and they won't be in effect this year, in all likelihood. The next kind of major issue is dealing with separated spouses. As we know, separated spouses don't lose their status as beneficiaries or executors just because they're separated. Divorce would have that effect, but separation wouldn't. What the idea is that, and I'll talk about this very briefly, is that if you're separated at the time of death, then any gifts that were made to you in the will are revoked, and any appointment of you as the estate trustee is revoked, similar to as if you were divorced. Similarly, separated spouses would not inherit on an intestacy. I just want to take you through to the definition as proposed of separated. And they lived separate and apart for 3 years as a result of the breakdown of their marriage. That is the definition that is proposed for determining whether somebody was separated at the time of death. Similarly, if they entered into a separation agreement, if there's a court order or arbitration order, and the reason they were separated was because of breakdown of their marriage. So not just because they were, one was in a nursing home or something like that. So the last point, and I just want to cover a couple of things. First of all, you are required to file an estate information return for a small estate. As far as I'm aware, all of the same rules apply. The increase, and I mentioned about the increase in value for a minor. It is $35,000. Thanks, Max, for that. $35,000 has been amended by virtue of the regulations. Just wanted to make that point, and we'll make that point as well. And then the last proposal, this is fundamental to us, is that they're proposing to have substantial compliance legislation for Ontario. So as many of you know, we have strict compliance, which means the will has to be signed exactly in the right manner, 2 witnesses in the presence, subscribing to the will, et cetera, et cetera. Many other jurisdictions allow for where there's a mistake made in the due execution, a minor mistake that the will could still be probated. And that's what is proposed here, that if a document that was not properly executed, you can convince a court that it does set out their intentions. They can order it to be valid. And same for revocation and other changes to the will, even if it wasn't executed properly. So that is again, not yet in place, but that's what's on the table. So those are what we've got. Obviously, Doug Downey, the Attorney General, has moved, in our business very quickly in proposing a bunch of changes. I had the good fortune of having him speak to my law school class, and he, said that yes, what COVID has definitely, led to the speed up of legislative changes, because things have to get done, and so we're seeing the effects of that. So I will get back to everybody on the issue of whether a bond can be dispensed with for an estate of less than $150,000, even without a small estate certificate. Other than that, I think that's all I had to say. We finished right on time. If anybody has questions, I'm happy to try to answer it. Of course, we don't know all the answers. It's brand new, but hopefully that's been of assistance. And welcome to eState Academy. If you've never been to one of our Thursday webinars, we hope that you'll join us again.